something on his hip.
This is Officer Josh Sheldon in 2011. He was an investigator under the control of Sheriff Justin Smith at the Larimer County Sheriff's Office in Fort Collins, Colorado. It would take nearly 10 years to find out who he is and why he was walking around my SUV. It took almost a decade to learn the facts about how he broke the law and why he did it, because Sheriff Justin Smith, Sheriff John Feyen, and Larimer County Attorney David Arode hid the records for nearly 10 years. A few weeks ago, Josh Sheldon's dirty history as a cop was revealed in a new Colorado Criminal Justice Records Act answer to a request I filed with the District Attorney's Office in the 8th Judicial District. The new official records about Josh Sheldon's life as a cop made this update about the lawsuit against Sheriff Justin Smith much more interesting. In March 2025, the District Attorney's Office answered my request for the 8th Judicial District Brady list. Many people were shocked to see Brian Koopman's name on the list because nobody knew. You can catch up on that part of this story by watching the videos posted on March 27th, March 30th, and April 9th. And then I noticed that Josh Sheldon was Brady listed in 2015, 4 years after Sheldon illegally attached an actively tracking GPS device to my SUV. It was illegal because there was no probable cause and no warrant. It's interesting that Sheldon was Brady listed to the day of his illegal attachment of that GPS device to my SUV. What are the odds that that was a coincidence? Anyway, I was not aware until March 26, 2025, that Josh Sheldon had been Brady listed 10 years prior, and that the local newspaper, the Fort Collins Coloradoan, ran a front page story about Sheldon's lies in 2012. And as usual, Sheriff Justin Smith lied to the public about Sheldon's dirty cop history. Fort Collins, Coloradoan reporter Robert Allen wrote about Sheldon's under oath, quote, lie about his role in a cocaine deal, end quote. The cocaine lies and the cocaine deal that Officer Josh Sheldon was involved with included William Scott Pettigrew. Now, Pettigrew's attorney told the Fort Collins Coloradoan that, quote, once an officer has shown a willingness to lie under oath on any case, especially a district court felony, he's subject to impeachment on truthfulness on all future cases. Obviously, it will be a problem for prosecutors and Mr. Sheldon for some time to come, end quote. Again, that was Brad Allen, Pettigrew's defense attorney. The December 12, 2012 article about Josh Sheldon's tarnished truth is missing vital information, as is Sheriff Justin Smith's response to the article. The next day, December 13, 2012, on the official Larimer County Sheriff's Office Facebook page, Justin Smith, speaking as the elected sheriff of Larimer County, expertly deceives the public about Josh Sheldon. Sheriff Smith tells the public that it's no big deal that Sheldon lied under oath. Sheriff Justin Smith accuses the reporter of being, quote, sensational. Smith shifts the focus away from the actual facts about Sheldon's under oath lies by telling the public that his own office had, quote, vigorously investigated it, end quote, and found no problem with Sheldon. And gee, even the district attorney's office is still filing and prosecuting Sheldon's cases. Justin Smith's trick is this. Smith left out the facts that provide accurate context. In a letter written by First Assistant District Attorney Mitch Murray on November 8, 2012, that he, Mitch Murray, along with DA Larry Abrahamson, Assistant DA Cliff Riedel, Chief DA Michelle Brinegar, Emily Humphrey, Andy Lewis, Deputy DA David Vandenberg, and himself, Mitch Murray, decided that their office, the district attorney's office, would need to make the information in the letter available to the defense in cases in which Investigator Sheldon is to be a witness. If Sheriff Justin Smith would have been honest in his Facebook post about Josh Sheldon's lies, then Smith would have told the public that Josh Sheldon repeatedly told Deputy District Attorney David Vandenberg false information. Interestingly relevant in the big picture of how corruption breeds and recycles is that Sheldon's supervisor, Joe Shellhammer, who is now Sheriff John Feyen's undersheriff, met with the DAs about Sheldon's problems. And in the category of you can't make this expletive up, it's wildly ironic that it was Deputy District Attorney David Vandenberg who, quote, brought this case, end quote, to DA Murray's attention. It's ironic because 10 years later, in 2022, another dirty cop, Sheriff John Feyen, would hire David Vandenberg to defend him, John Feyen, in a lawsuit that is right now being litigated. In Josh Sheldon's affidavit of warrantless arrest, Sheldon's bogus, quote, reasonable suspicion, end quote, that he used to search the defendant's car with a drug-sniffing dog was based on Pettigrew's, quote, body language. Body language is not legally considered to be reasonable suspicion. Sheldon knew he was violating the defendant's rights, but he didn't care about the law. He wanted another notch in his badge. District attorneys who become judges know who the dirty cops are because they have dealt with them on cases as DAs. But that does not factor into their rulings when those same DAs become judges. Even when a dirty cop is Brady listed and the defendant is notified that the cop may have a dirty history, a judge can override the defendant's right to know, as Judge Stephen Howard did here in Josh Sheldon's case. The judge can keep secret what is actually in the dirty cop's file because nobody else gets to see the documents that the judge looks at in private. This is the Brady notice that is required to be given to a defendant who has Josh Sheldon as a witness in his or her case. This Brady notice alerts the defense attorney that the Brady-listed officer has an unclean history. Every law enforcement officer who is on the Brady list is legally required to have this notice sent to every defendant that officer is involved with. When a dirty cop breaks the law to get an arrest or to retaliate against the target, or for whatever reason the deviant officer chooses, the impact on society, including other law enforcement officers, can be severe. The defendant in Josh Sheldon's Brady case, William Scott Pettigrew, got his 2010 drug case dismissed because Sheldon broke the law. Sheldon's lies and constitutional violations in Pettigrew's 2010 case let Pettigrew free and out of custody to do this: attempted murder, child prostitution, drug cases, burglary, and kidnapping. And then in 2015, when Pettigrew was finally being held in Larimer County Jail, he assaulted 2 deputies. This is how dirty cops in Larimer County keep their jobs. Dirty sheriffs and corrupt police chiefs hide troubled officers from the district attorney and from defense attorneys. And the corrupt law enforcement agencies use tricks that override the district attorney's Brady list. Throughout Brian Koopman's corrupt career, the City of Loveland Police Chief Luke Hecker and Police Chief Bob Tyser rewarded Koopman with promotions and publicly praised him for his deviance. After dirty cops get Brady listed, fired, quit, resigned, or retired, they commonly go into a consulting business, as Josh Sheldon proclaims on LinkedIn. Okay, back to the update in the lawsuit against Sheriff Justin Smith. If you are interested, you can read the full April 30th, 2025 reply brief that was filed with the Court of Appeals. You can also read a prior order denying Smith's motion, a prior order denying John Feyen's motion, Justin Smith's notice of claim, This is a concise summary of Smith's lawsuit. John Feyen's notice of claim. This is a concise summary of that lawsuit, and is also the exhibit that is at issue in Smith's deposition clip. By clicking on the Google Drive links in the introduction to this Facebook post, you can read all of those documents in their entirety. Today is Wednesday, April 30th, 2025, and I am back in Denver, Colorado at the Colorado Court of Appeals, Colorado Supreme Court building. I have just filed my reply brief in the lawsuit against Sheriff Justin Smith. I'm suing Sheriff Justin Smith and Sheriff John Feyen because they both lied, maliciously defamed me, knowingly, intentionally lied about me so that John Feyen could be elected as sheriff of Larimer County, Colorado. It's impossible to separate John Feyen and Justin Smith from Brady Cop Brian Koopman, and as these videos progress, I will show you easily how those three are tied together to combine to make some of the most corrupt law enforcement officers in a county. Justin Smith's case is at the Court of Appeals because his attorney, Brian Reynolds, destroyed evidence that proved Justin Smith's actual malice. In a defamation per se case involving public figures such as Sheriff Justin Smith, Sheriff John Feyen, and myself as an investigative journalist, I have a high burden to overcome. That means I have to prove that Smith and Feyen knew when they were lying that they knew they were lying. And in this case, it was easy because we are able to use Justin Smith and John Feyen's own law enforcement records that prove that they knew they were lying when they lied. Remember, they lied about me so that they could get John Feyen elected. Now, they did that in spite of the fact that there was a clean cop running against John Feyen. Jeff Fisher was clean during the campaign, he was clean before the campaign, and he's clean now. That's rare to say about law enforcement officers in Larimer County because if you've had any interaction with John Feyen, Justin Smith, or Brian Koopman, you're guilty by association. This is Jeff Fisher, a former longtime Loveland Police Department officer in good standing, speaking about the Loveland Police Department to the law enforcement accreditation organization called CALEA in August 2015. Jeff Fisher has been doing the right thing. By the right thing, I mean following the law and adhering to elevated ethical behavior, even when it caused significant stress in his personal relationships and risked his professional advancement.
Good evening. My name is Jeff Fisher. I'm a Loveland resident and a retired sergeant from the police department. I left in December of last year. I'm now a division commander in another Colorado municipality. I'm here to speak against the reaccreditation of the Loveland Police Department. I have a unique opportunity to be both a Loveland resident and also be a former employee of the police department. There are a great number of reasons I don't support that reaccreditation. A great number of concerns that I have about the organization. We'll remit those concerns to you in writing for two reasons. First, in the interest of time, and secondly, quite honestly, there are a great many people in this room, men and women I've known for a long time, and about whom I care very much and have a great deal of respect. Some of those things may serve to embarrass them in this forum, and that's the last thing I would ever want. So I'd just like to put on record that I do not support the accreditation, and additional comments will be forthcoming. I'll still remit that in writing. Appreciate that. Thank you. Thank you.
For today's filing, I am on the opposite end of the Colorado Supreme Court building because that's where the parking spaces were. But it's ironic because at this moment, as we speak, the Colorado Supreme Court Office of Attorney Regulation Counsel, which is in this tower, along with the Attorney General for the state of Colorado, the Office of Attorney Regulation Counsel is investigating Brian Reynolds because he, on behalf of his client, Justin Smith, destroyed evidence that proved Justin Smith knew that he was being malicious when he lied about me. Justin Smith, through his attorney, didn't simply destroy evidence that proved his guilt. He also blocked my access to having fair discovery, to having the opportunity to depose Justin Smith. Justin Smith, through his attorney, Brian Reynolds, objected more than 370 times during the deposition of Justin Smith. That's an extraordinary, phenomenal amount of objections. 8th Judicial District Court Judge Stephen J. Jouard issued an order about Brian Reynolds' extremely outrageous departure from the law and from ethical rules that apply to him. The order that Judge Jouard issued actually is what landed Brian Reynolds in an investigation by the Colorado Supreme Court. So the short story is that John Feyen, as the Assistant Chief of Police at Fort Collins Police Services, lied during his campaign for sheriff. He lied about his illegal criminal actions. He placed a GPS tracking device on my vehicle without a warrant, left it there for more than 4 months.
The courts have said that mom is not fit mom.
Under oath during testimony at an evidentiary anti-SLAPP hearing in the current lawsuit against John Feyen for defamation per se actual malice, John Feyen admitted that he knew there was no court order saying that I was not a fit mother. At the evidentiary hearing, my attorney asks Feyen, "You also say that the courts have ruled that she's not a fit mother. You said that?" Feyen says, "If you say so." My attorney says, "Okay, but you were not aware of any court order that said she was not a fit mother the second time you said it." Feyen said, "I was not."
The courts have said that mom is not fit mom.
Because Feyen repeatedly lied about me to live audiences and via live stream on social media, my attorney repeatedly got Feyen to admit at the evidentiary hearing that John Feyen knew at the time he lied about me to the voters and to the world on February 2nd, 2022, that he knew then that what he said was false. Pause the video if you want to read Feyen's exact admissions. After District Court Judge Joseph Findley heard John Feyen's testimony at the anti-SLAPP evidentiary hearing, Judge Findley denied Feyen's motion to dismiss. Judge Findley, in his order denying John Feyen's motion to dismiss, writes, "Plaintiff has clear and convincing evidence of these statements because they are both evidenced in video and/or in writing." Judge Findley ruled that I met a high burden and showed clear and convincing evidence that John Feyen's statements were defamatory per se and made with actual malice. Actual malice means that John Feyen knew he was lying when he maliciously defamed me in front of countless people in live audiences and on social media during his campaign for sheriff. After Judge Findley repeatedly ruled against John Feyen and issued numerous rulings in my favor, Judge Findley disqualified himself and disappeared from the case without explanation. Sheriff Justin Smith lied about what John Feyen did with that tracker, and Sheriff Justin Smith lied about what he did with that tracker. So they used lies about me to get John Feyen elected. That's not acceptable. In my world, the most offensive thing to me is deception, blatant lies, and I cannot let the record show things that are not true. When I discovered the GPS tracking device underneath my vehicle back in 2012, May of 2012, we're coming up on the 13-year anniversary of finding that GPS tracking device, and that tracking device and the illegal actions by John Feyen and Justin Smith are still relevant and still current today in 2025. After I found that, the Hyde Park fire broke out in Larimer County. So the GPS tracking device was getting a lot of attention nationally. There was some worldwide coverage, but it was mainly national attention because it was so outrageous that a cop placed a GPS tracking device on a journalist's vehicle without a warrant and then tracked her, actively tracked me. He lied about that, by the way. He told the public and he told the voters that the tracking device was never turned on, but that wasn't true. It was turned on. His own officers said it was turned on. There's written reports that say it was turned on, and there were at least 900 records. So John Feyen is a liar. Brian Koopman is a liar. Justin Smith is a liar. And all three of them, Feyen, Koopman, and Smith, have a pattern, a verifiable official record pattern of lying in their official capacity. That's why I'm here again in Denver, Colorado, at the Colorado Supreme Court. And can you direct me to the page exactly where I smeared upstanding members of the LCSO? That's what we spent all this time doing. Where did I smear them? Which page number?
There's not a page number. There's multiples where you refer to other employees beyond John Feyen, Jeff Van Hook, Joseph Shellhammer. Additionally, let's see, there's references to Captain Coleman by name. Those are specific ones that I
How was I smearing them? By referencing their names. How was I smearing them? By quoting from their record. How is that smearing them?
There were statements, again, continually insisting that you were illegally tracked and that you were tracked for a long period of time, that you weren't given notice of the court case. Those things, by making those statements that I don't believe are supported and I believe are inaccurate, to me is a smear on their names that they were doing illegal actions, and I don't believe that's the case.
So I would like you to, we spent all this time so you could read it. I would like you to point me to where I smeared, let's say, choose one of those names, Captain Coleman, Kevin Mall, choose a name and show me where I smeared it in that document.
Objection asked and answered. He said that his answer is the totality of the document is smearing in general. You
cannot testify for your client. He can answer for himself.
Stop interrupting me, Ms. Lynn. Objection asked and answered.
Mr. Smith, can you point me to a specific instance in that document, Exhibit H, which is the notice of claim against John Feyen, point me to a specific instance where I smeared a specific Larimer County Sheriff's Office employee? One instance.
Again,
not a general. I want one specific instance.
I'm sorry you interrupted me. Are you done? Again, it's the overall references to naming individuals and referring to these actions as being illegal and intentionally illegal actions multiple times throughout here. That together, in my experience, is what smears their reputation, and it is signing ulterior motives, and the same with the documents that were later released to you, that you make a statement that it's intentional, and that's not accurate.
That what was intentional?
That you did not get those records until I believe it was 2019.
And which records are you referring to?
Those were records that tied to the GPS device.
Are you saying it's inaccurate that I didn't get the records until 2019?
No.
What are you saying is inaccurate?
That you said that it was an intentional hiding of the documents, and that is inaccurate.
How is that inaccurate?
It's not accurate.
Are you saying you did not intentionally withhold the documents?
I believe I said that the statement that documents were intentionally withheld from you is inaccurate.
We'll get back to that. So I'm going to make a note. Can you tell me what time we're at on your
We're at 1 hour and 30 minutes.
So we're going to come back to this in a different exhibit. And we're going to reference, this is just for a clear record, that the withholding of the documents on the GPS device was not intentional. That's the general testimony. Is that correct?
Objection asked and answered.
Can you restate the question?
Yes. Is it your testimony that the documents on the GPS tracking device were not intentionally withheld?
Yes.
And then I noticed you were making marks in the Exhibit 8 that you handed back to Mr. Reynolds.
Yes.
How many marks did you make? Could you count those real
I
quick,
didn't
please?
count, yes. Restate your question, please.
How many marks did you make in those 13 pages in Exhibit 8?
At least 22.
At least 22 marks, and those were all of the places that you say are inaccurate, are smearing, misinformation, completely false allegations, and false information. Is that what your testimony is?
It would be or, not and on each of those. But that they were, it would be my notes that those were areas that jumped out to me as inaccurate.
So the record's going to show that I have given you a lot of time to review this document, and I have asked you repeatedly to give me one specific example of a completely false allegation, a factual inaccuracy, a false narrative, and false information. I want one specific example from this Exhibit 8.
I believe I answered those with multiple items in there in general. Some of those are duplicative where I made marks, but there were multiples that I told you about.
Well, you said in general, but I'm asking you to give me an exact name of a person with an exact misinformation, completely false allegation. I want one specific example.
You state that no efforts were made to recover the tracker. It was a statement reference to Joseph Shellhammer. That's not accurate.
Which page is that on?
I'd have to go back.
Please do.
page 12.
Which paragraph?
I'm seeing paragraph 2 specifically.
And which line?
I'm seeing it starting with line 3.
Now on line 3, it begins with a quote mark. Do you see that?
Yes.
And what specifically are you saying is inaccurate?
The overall context of this is saying that no efforts had been made to locate your vehicle and get the tracker back, and that's referenced multiple times in there, and that's not accurate.
Well, you just directed me to page 12, paragraph 2, line 3, and it says, quote, according to Sergeant Shellhammer, this is a quote. That means, do you know what that means?
Yes.
What does it mean?
It's a direct quote of somebody's words.
And you're saying this sentence shows smearing sheriff's office employees, it shows inaccurate information? Is that what you're saying? This is your example of a smearing, inaccurate, completely false allegations? For the record, I'll read the whole sentence. Quote, according to Sergeant Shellhammer, he drove past Lynn's last known address for once a week for the next 4 weeks and did not see her vehicle, nor did he see any indication that she was at home, end quote. That's your example?
I said starting with that quote.
And then how far would you like me to put on the record?
I was referring to the whole paragraph.
As an example of smearing LCSO employees and as an example of completely false allegations, this is your example? I want to be clear for the record because I'll read the rest of the paragraph.
I said inaccurate information. You asked me for anything that was inaccurate, I believe, and that's what I'm referring to as inaccuracies.
Okay, so I'm going to finish for an accurate record. Mr. Smith has said that paragraph 2 on page 12 is his example, one example that he has marked 22 times of inaccurate information and smearing upstanding members of the Larimer County Sheriff's Office. Resuming the quote, he, in parentheses, Shellhammer, did advise that he eventually observed what he thought was the vehicle parked in the driveway of Lynn's residence with no tire tracks observed in the snow, end quote. ABC Channel 7 News said they, quote, confirmed they, Larimer County Sheriff's Office, never went to her home to actually get it from her property, end quote. But, Sergeant Shellhammer told Captain Coleman that he drove past Stacy Lynn's address for 4 weeks and did not see her vehicle or any indication that she was at home, and that he eventually saw the vehicle parked in the driveway. For that to happen, for Sergeant Shellhammer to see a vehicle in the driveway, he had to have been 1/2 mile up the winding, steep, densely forested driveway on private property. The driveway and any vehicle parked on it are not visible from any public roadways. The driveway and any vehicle parked on it are not even visible from any neighboring properties. Moving on.
Justin Smith's defense attorney, Brian Reynolds, understands what just happened with that one exhibit. Smith's testimony about that exhibit proves actual malice, and that is why Brian Reynolds destroyed it, shredded it, even admitted in writing that he destroyed it. And that is absolutely not legal. And that is one of the many reasons why Reynolds is being investigated by the Colorado Supreme Court. This is the paragraph from page 12 that Sheriff Justin Smith pretends to show, quote, inaccuracies in my notice of claim against John Feyen. The quotation marks in the paragraph below are taken directly from official law enforcement records that were written by officers at the Sheriff's Office and from an ABC News story about the illegal GPS tracker. If you are curious about how far Sheriff Justin Smith strayed outside of the law to get his co-conspirator elected, read the notice of claim that is linked in the Post intro. The short story is that Sheriff Justin Smith falsely and maliciously accused me of writing, quote, completely false allegations, end quote, about John Feyen in the notice of claim against John Feyen. And then on June 11th, 2022, Sheriff Justin Smith, using his official government Sheriff Justin Smith Facebook page, for the first time in 11 years, claimed responsibility for John Feyen and Josh Sheldon's illegal acts, even though in 2011, Smith claimed that he did not know what was happening.
Something on his hip.